Well, good afternoon, everybody. I am Charter Morris. I'm Director of International Student and Scholar Services. It's now 3 o'clock, and I want to be mindful of everybody's time, especially to our presenter. I want to thank you all for joining us today. The registration for this has been very good, actually. We had about 170 students register today. Many have said that they were not going to be able to attend, which is understandable, but just to be clear up front, we are going to record today's session, and in a few days we'll have it uploaded and we'll share it back out as a link to everybody who maybe wants to go back and review things, or if they have we're unable to attend any of our students, they'll be able to at least hear the session presentation. Now, Carol Armstrong is an immigration attorney here in Tuscaloosa, Alabama. She's she's the contract attorney for the University of Alabama and the UA system for immigration law. So she handles a lot of our green card cases and stickier cases here at the university. We've worked with Carol for many years now, before I even got here. So 10 plus years, right, Carol?
It's been almost 2 decades, moving close to it, yeah.
So she's helped us through a number of cases, and once a year she hosts this this seminar to just talk to students about their immigration path, what there might be after graduation. So we're going to talk a little bit about that today. We'll have plenty of time for Q&A at the end. I've blocked off a pretty significant amount of time for this. So if you want, you can put any questions that you have as you think of them in the chat, and I'll be monitoring that. And then we'll open it up to Q&A. But if I see things in the chat, I'll come to it when it seems appropriate in the talk. So with that, I just want to also recognize a couple of other folks here in the room. So Joe Hawley from the Career Center is here. Joe, do you want to say hello? Or Joe's waving right now.
Hi, everyone.
So Joe has been working with us on this. So the Career Center is a great partner of ours. They do a lot of great programming and events, but really and truly, they're going to be one of your best resources here at the University of Alabama to help hopefully find your career path. So they do a lot of advising. They host these amazing career fairs. And they have some great skills building courses and tools to help you build your resume and hopefully get your foot in the door with the right employer. So Joe is here, and I believe Amy Ratliff's also on the call or on this Zoom today. Amy has worked with us for many years, and she works over in the advising offices in the CNIS, College of Communications and Information Studies. Also on this is Trong Nguyen. I don't know if you want to say wave as Trong. She's our primary student advisor, but she is moving into a new role starting next Monday. She'll take over doing our scholar work. So she is going to be doing the H-1Bs and employment visas for the University of Alabama. She'll still do advising for students, but she'll be kind of shifting over her primary focus while we search for a new full-time student advisor. So, and with that, I do want to turn it over to you, Carol, so that we can get started and you can share all your great wisdom with us.
All right, well, good afternoon, Charter, and thank you guys for getting this set up. I know that this information seems to always be very helpful for our students, and want to just kind of give you some insight on planning today. I know many of you may still have, some time before you're actually going to be completing your program of study and moving on into OPT, optional practical training. But this gives you I want to make sure that you're aware, and I think it's helpful for you to understand what options there may be for you. What questions do you need to be asking potential employers now? I also invite the career services folks to be sure to just jump in when there are things that we touch on and the career services office can assist with, because I know that they work diligently to help with placement and help you find the kinds of employers who are sensitive to the needs of foreign national students, period. So I know to begin with, probably if you haven't already gotten something from Charter's office about timelines and information about optional practical training, if you haven't gotten it yet, you probably will soon. Charter, do you or Trong want to maybe touch on that a little bit, just to give folks an understanding of that benefit as well as the timing?
Certainly, and Trong, feel free to step in too. So many of you are probably towards the middle of your program, but maybe nearing the end. Some of you might be in your first semester, so it's never a bad time to start thinking about the future. So for F1 students, and the majority of you are on F1 student visas, you have a couple of work benefits for you. And one is curricular practical training, which usually is used during the degree for internships related to your major. Not all students take part in CPT, that's the short form for it, but almost all students are also interested in optional practical training. So as a benefit of graduating as an F1 student, you can apply for optional practical training to get training in your field post-graduation. And it allows for a year of training per degree level. And if you happen to be in a STEM field, it's possible to seek a 2-year extension of that. Meaning if you're in science, technology, engineering, mathematics, if it's a related STEM field and if it's on the recognized list and you have a degree in that area and your employer meets certain requirements, you can seek extensions even beyond that 1 year. What that usually means is you get a good 1 to possibly 3 years of experience, but it also gives you a bit of a bridge between your studies and your work visa sponsorship. So many of our new employees here at the university begin with us on OPT, and then we transition them to H-1B. So that's one of the things that Carol's referring to. But it's timeline, it's important to start your OPT process about 3 months before graduation. The earliest you can apply is 90 days before your graduation date. And so you want to make sure to submit that OPT application as early as possible. And it may be that you have not got a firm plan about where you will work, but you do have a firm plan about when you're going to graduate. So we want to make sure that you're starting early, and just be assured that you don't have to have a job offer in your hands in order to apply for PR or apply for OPT. So what I want to do is just stop there and let it kind of go back to it. Trong, am I missing anything about timelines that you would want to mention? Or you have to unmute.
Okay. I think you've covered the major points of OPT and STEM OPT. The only things I want to add is that even though, you don't really need a job offer in hand to apply for OPT, but you do need it for the STEM OPT extension. And because, the processing time for OPT and STEM OPT with USCIS could be long. And so just to repeat what Charter just said, that you want to start, if you plan to work, you want to start that process quite early. The earliest date is 90 days that you could file, but you can start the process on your own even more than 90 days in advance, because filling out the forms, getting signatures from departments could take some time as well. So just kind of keep that in mind and plan your application so that you can have that card as soon as possible when you're in your job search.
So, and by the way, we're getting pinged with a lot of questions, some of them direct messages. So a couple of things that are related. One person asked about STEM majors. If they had a STEM degree at the undergraduate level, can they use it, the 2-year STEM extension after graduate studies? That's an interesting thing, is STEM eligibility, if you have a qualifying degree, even if it's from a previous degree as long as it was a US degree. So if you got your bachelor's in the United States and it was a STEM field, and then you finish a master's degree, maybe it's also a STEM field, maybe it's not a STEM field. It is actually possible to get a STEM extension based on a prior degree, but it has to be a US issued degree. So your undergraduate or your previous graduate degree has to be a STEM field. So that is a possibility. We talk about that a lot on our OPT page. Another question that came in for consideration, it sounds like a PhD student. Should those who are applying for postdoc and academic positions apply for OPT as well? Absolutely. Even though we can do H-1B sponsorship as a higher education institution, it is sometimes time consuming. And the thing is, your OPT will travel with you. For some postdocs, they run into situations where at some institutions, I've heard they just don't sponsor H-1Bs for postdocs. They just have a blanket policy for that, in which case OPT might be really your only option for moving forward with that. There's a couple of things about the degree list, and Trong, I'm going to ask if you can to look up the STEM field list and send add that link to the chat box. That might be helpful. So we don't make that determination. So just to make it clear, every degree offered by the University of Alabama has to be approved by the Alabama Commission of Higher Education, our state agency, and it's assigned what's called a CIP code, a CIP code. And so those are usually a really direct correlation. And so based on those approvals, those basically accreditations that we get, that is the CIP code associated with your degree officially. And the STEM list is officially kept by ICE, Homeland Security. They publish that list every 10 years, they update that list. And so if your major has CIP code X and that same CIP code appears on the official ICE list for STEM majors, then yes, you would qualify for a STEM extension. But if it isn't, then you don't. And there are times where degrees will sound as though they should fit on the STEM list or be very close to a STEM degree. The thing is, the official CIP code is what is set by the state of Alabama, and we have no control over that. So in any case, what was going to happen is that Tron was going to add, if you can, a link to the STEM list so that you can look into that. If you have doubts or questions, you can always come talk to us about that. There's a lot of subtleties to the STEM considerations. All that being said, some timing considerations: apply early, especially for your initial 12-month OPT. Which is for most of you. So in your final semester of study, you want to file about 3 months before graduation. I always recommend filing. And let me just be clear, it makes more work for this office. So I have no inherent interest in keeping you on OPT. It actually is not any easier. We don't collect any fees for this or anything like that. All fees are paid to immigration services, not to us. But it's a huge benefit of F1 status. And so you don't want to lose that because it's still dollar for dollar. The cheapest work authorization you can get is OPT. And OPT follows you, not the employer, meaning you have the flexibility to change employers with very little difficulty while you're on OPT. The other thing that I really want to stress is that the reverse side of it is, what if you graduate? How long do you have after graduation to apply? You have a 60-day window after graduation to submit an application. So you have 90 days before and 60 days after. So it's a total of 150 days window, but basically 3 months before, 2 months after. But when they count these, they count them by the days, 90 days and 60 days. So keep those things in mind. I am going to quit talking about OPT, but it is something that's very important. And I think that was actually the first slide in all this, is getting into the jungle.
Right, thanks, Charter. One thread that you're going to hear consistently today from me and from Charter and Trong as well is plan early. Don't wait to the last minute. Be prepared for delays. And even sometimes delays that we don't anticipate. Obviously, COVID has had implications across the board, across the world. But for immigration processing, it has been particularly impactful on processing times. And as Strong mentioned, some of these applications for OPT work authorization are taking quite some time. And if you are graduated or you have graduated and you have an employer, but then you can't start work because you don't have your OPT card, then you very well may lose an opportunity with that employer if you're not being proactive and making sure that you're filing well in advance of the applicable deadlines. Okay, so let's talk a little bit about what happens after OPT. As Charter and Strong mentioned, you can get the first year, and if you're in one of the STEM categories, then you can certainly apply with there's some additional steps, as Strong mentioned, having an offer letter and that sort of thing. But you may get an additional 2 years of STEM OPT time that could give you a full 3 years of work experience. And that may be, an opportunity when you're initially hired that this employer may not be willing to go in and sponsor you for another type of temporary work authorization and status, or even permanent residency, until you have demonstrated to that employer that you're an employee that that company wants to keep. So, and I'm sure folks in career services will back me up on that. Sometimes it takes time to get these employers to be willing to sponsor you in some of these immigration categories, just because they're not sure about the process. As I've mentioned before in these workshops, if you're going to work for, let's say, Microsoft, they've got their own, probably a few floors of immigration attorneys who handle their stuff. But if you're going to work for ABC company and, downtown Mobile, maybe, then you may not have quite they may not be savvy to what's involved with immigration and all of the costs and the fees, because immigration processing can be very expensive for employers. And so they may want to have some time to allow you to work without having to worry about sponsorship on the front end, and to let you establish with them your good work and your ability to be a contribution to that company. You guys in career services have anything to add to that? Did I lose them?
No, ma'am. You're fine. You were
okay.
Good to
sorry.
Go.
And I would think, Joe, you guys probably do have the opportunity to help guide students toward employers that may be a little more comfortable with sponsoring a foreign national, and helping the employers know what those particular needs are, but also encouraging and guiding the students and being able to get face-to-face with the employers who are willing to take on the immigration sponsorship.
Yes, ma'am. Every year when we have our career fairs, our main career fairs, we always have the employers that let us know which visas they do support. So yes, ma'am. Every single semester.
And there are some companies that just aren't going to do it, period. They just don't want the additional red tape, so to speak. They don't want the additional expense that comes with it. But even if you go to work for one of those employers during your OPT period, not only have you gained experience with that employer, but maybe your contributions may change their mind. Not necessarily, but even if the first employer that you have is not willing to sponsor you for an H-1B or permanent residency, at least you've got some experience under your belt to help you find an employer that would be willing to do so. Okay, maybe next slide, Charter. We talked about, basically OPT is not going to last forever. So what I want to do today is talk to you about some other types of temporary immigration status that also give you the ability to work in the United States as well as travel outside of the United States if you should need to. A lot of times, obviously, if you may want to go home and visit family or friends, but your job may also require some travel. So you definitely need to have the ability to travel. Before I launch too far into the H-1Bs, Charter, would you or Trong like to maybe talk to them about traveling during that OPT period and what they need to be aware of and careful about during that period?
Trong, you want to take this?
Traveling on OPT, generally, if the OPT application is still pending, we advise against traveling, especially if you've already graduated or completed your program and your OPT is still pending. You're kind of like in a limbo. You're not really actively enrolled students anymore, but not yet in your OPT period. So even though, there's no restriction or anything saying that you can't travel, the risks could be high, especially if you need to renew your visa. Then if you get into, and if, say, while you're abroad and your OPT application, USCIS may send something called an RFE or request for evidence. Things that they need more information from your end before they can make a decision on your case. And if you are abroad, there could be delay in terms of getting these information to USCIS, and it will eventually impact your OPT. So for those reasons, we recommend that you do not travel while the OPT is pending. When it is approved, the risk could be a little bit lower. However, if you still have to, renew your visa, we ask that you're at least have some sort of proof that you have an appointment or, a job position with a company. Because eventually the purpose of OPT is for you to work in the US to gain experience. And if you do not have a job, an officer may determine that, oh, well, you don't really have a valid reason to come back to the US. I would say if you have a job offer, if your I-20 is signed for travel, and talking about that, the travel signature on your I-20 is only valid for 6 months when you're on OPT. So you need the job offer, the E-80 card, the I-20 with the travel signature on the second page. Your passport is valid. You'll reduce the risk of, being denied a visa or denied an entry to the US. But with any international travel, there's always some sort of risk, even if you're not on OPT and you're only a student. Just so you know, well, right now with COVID, any international travel could be a huge risk. So yeah.
Thanks, Tron. I appreciate you touching on that, because with any type of status, when you're applying to renew your visa, or if you are just applying to enter the United States, you can always be told no, even if you have a visa. So making sure that when you're planning travel, be sure to talk to your advisors and make sure that is actually a good idea at the time. Like she said, there's always risk with traveling and returning. But as she mentioned, there are times when it is much more riskier than others. So, unless there's some sort of emergency, we would caution against traveling with the understanding that you may not be able to re-enter. But once we get from, let's say you go ahead and you graduated, you've gotten your OPT, you've got your STEM extension approved, and you're winding down into that third year of your STEM OPT, and you're starting to think about, this is going to run out. What should I do next? Again, as we talked about, being able to have conversations with your employer at the very beginning is important to make sure that the employer understands. As a foreign national, you have to have permission not only to be in the United States, but also permission to work. And in some of these types of status will permit you to work for any employer, for example, your OPT. Other types are only valid for a particular employer who files for you or sponsors you. The H-1B is a category that's used a lot. The H-1B is for specialty occupations. And what that means is that the job itself requires that you have at least a bachelor's degree in a particular field of study. So for example, if you've got a degree in engineering and you find a job as, I don't know, managing a clothing store, that's not going to work. Your degree has to match the field of study for which the employer actually requires. So for example, if you're if you have an accounting degree and you're going to work as an accountant, well, that clearly qualifies for an H-1B. If you have a civil engineering degree and you're going to work in a civil engineering firm, that clearly works as for the H-1B. Keep in mind, if the position that you have requires any sort of licensure, for example, a lot of times accountants, any medical fields, engineering sometimes can require certain sorts of licenses. And if you have to have a license, then you will have to demonstrate that you have that when you file for your H-1B. But let's talk generally about the H-1B program. The H-1Bs there are a finite number of those available each year for certain types of employers. So for cap subject employers, that means employers that are subject to the annual cap on H-1Bs. There are a very limited amount of those available. Okay, so in prior years, what we expected is that there would be sufficient H-1Bs available for anybody who wanted to apply. And then the government cut back the number of H-1Bs that are available. And those are broken down by whether or not you have a U.S. master's degree or not. And so with the cap subject employers, there's a very finite window of time that you can apply. And there are usually about 3 times as many applications or petitions for those H-1B numbers as there are actual visa numbers available. And that's been our experience for several years now. So what does all of that mean? Maybe if you go to work for a cap subject employer, even if you're going to have a STEM extension, I always encourage folks to start that conversation early with that employer, because you want to make sure that you can get that you can apply for those cap subject H-1Bs as early as possible, even maybe in your first year of OPT, because of this lottery system. Basically, the employers have to register, and they usually do this in the early part of the year. And those registrations usually start around the 1st of March. And then all of those registrations go in, and USCIS, the Immigration Service, runs basically a lottery and selects so many of the registrations in the general category and some within the U.S. master's degree category. And then only those selected registrations can actually apply for an H-1B. And when I say we're applying in March, this is for a position that is going to start, or work authorization that is going to start on the following October 1, because that's when the government's fiscal year starts, is October 1. So I always encourage folks to be sure to start registration and applying for those cap subject H-1Bs at the earliest possible time. Now, if you are selected in that H-1B lottery and you submit an H-1B petition, then the good news is, although the H-1B will not start until October 1, you're at least going to be covered if your OPT is going to run out before October 1. Maybe Trong, you want to talk about the cap gap and what's involved with that, or Charter, either one of you, and what they need to do to make sure that they're getting that cap gap coverage to keep them where they continue to have work authorization.
Sure thing. So because of the way the lottery system has changed, it's still a lottery, of course, but there's the pre-registration and everything. It's been a lot smoother, actually. It used to be, they would receive hundreds of thousands of applications on day one, and literally it was like a lottery, because they would then choose like randomly out of the pile who was going to get processed and who was going to get rejected, and then on and on and on. But what this cap gap OPT does is, inevitably, if you're graduating in May, most of you will graduate in May. That's the biggest time of year for graduates in the US, May and June. So if you're graduating in May or June and you're applying for OPT, you're probably starting your OPT in May or June of that year. And if you only get 1 year of OPT, it's going to end in May or June the following year. So what cap gap does is it addresses the gap that is created by the H-1B cap system in the private employment sector. So for those that are cap subject, their H-1Bs don't begin until October 1, and it creates that automatic 2 to 4 or larger month gap. And so what the cap gap does is, if you are the beneficiary of a properly filed H-1B for a cap subject employer for a change of status, not consular processing, it will automatically extend your OPT from whatever the end date is until September 30th. So until the day right up to the point where the H-1B begins. Now, there's a lot of caveats there, like for your work extension, you have to have been on OPT with a valid work authorization post April 1st, and then the employer has to have filed before that OPT ended, and on and on and on. But if done properly and it's all submitted on time, CVIS will automatically update your I-20 with a cap gap notation with the additional days built into it. And so what you would do is just reach out to us. So if you've graduated, you've moved on to OPT, your employer has sponsored you for an H-1B, they got in on the pre-registration, everything went clearly and smoothly. All you have to do is reach out to us after filing the H-1, after the employers filed the H-1B petition, and request your cap gap I-20. Now, there's a possibility that the system didn't get updated, so we may need to ask you for some additional documentation. But generally speaking, it's pretty straightforward. Now, Trong is the one that usually ends up having to do the correction requests, so I may be speaking out of turn. And in your experience, Trong, would you want to speak to how smoothly it works?
Yeah, I would say for the most part, CVIS is pretty good in terms of, automatically update students' record if you're eligible and qualify for these cap gap extension. Most of the time that I've seen is that, like I can easily, print out your I-20 with the notation that you are on cap gap extension, and you can continue working up until October 1, when the H-1B takes effect. Now, if your CV is not updated, then I will need documentation from you and probably from the attorney who filed your H-1B to make the request and update that work authorization. Now, I have to say there's one little tick, is that one little issue problem that I've seen is that, if you happen to have to renew your driver license during those cap gap extension, it could be a pain because several DMV, because like each states will handle, their process differently, and what documentation they require could be different, very different from one state to another. And so some DMV and some states would not accept, students who are on cap-gap extension as being eligible to extend their driver license. So.
And one other note, Trong, if you're able to get the H-1B petition filed and you get your cap-gap, that period of time between, your cap-gap and the October 1 start date is definitely a period of time that you don't want to travel. Because you're going to get stuck out until you can apply for your H-1B visa. And that's going to be, 10 days before October 1st. That's not going to be optimal. If you already have an employer and are working for them, that's not going to be a situation that you want to be in. So that's definitely one of those times. Again, it's always worth picking up the phone or walking into International Services office and just say, look, I need to travel. Here's where I am and what do I need to do? And they can guide you on whether or not that's something that is in your best interest, because once you're in that cap-gap time frame, you're probably not going to get back in on your F1. Most likely you will not. You're not going to be eligible to apply for the H-1B and re-enter on it until 10 days before the October 1 start date. Well, let's talk about, we've been talking about cap subject employers. So all employers in the United States are subject to the H-1B cap unless that employer is exempt. And there's a statutory list that tells us what employers or what categories of employers are exempt from the cap. And if an employer, if you land a job with an employer who is cap exempt, we don't have to worry about all of this. You got to pre-register and there's going to be a lottery, and then we got cap gap, we got all these issues. Those cap exempt employers can submit an H-1B at any time of the year, period. Trong or Charter, do y'all happen to know an employer that might be cap exempt?
Absolutely. So any college, any university, private, public, for-profit, nonprofit, does not matter. If it is a higher education institution, we are broadly exempt from these caps, which means we can actually hire people to start in August when we actually begin our school year instead of October 1. I would imagine my faculty or department chairs' heads would spin if I told them new faculty couldn't start before October 1st.
And there are, obviously the institutions of higher education are exempt from the cap. And there are some other types of employers, some sort of governmental organizations, research organizations and the like that are exempt. So the main thing that you need to take away from that conversation is if you are looking at the possibility of filing for an H-1B, you need to have conversations with your employer early on, because if you've got a cap subject employer, and the employer can contact its immigration attorney or find an immigration attorney to help with the case, to make the determination on whether or not that employer is cap subject. If the institution, if you go to work for a university, then that university is going to be cap exempt, and you don't have to worry about all those timeframes. The employer still has to submit an H-1B petition for you and have that approved in order for you to have H-1B status and the related work authorization. But it's a much cleaner, smoother process than dealing with cap subject filings. Now, keep in mind, we talked about with the OPT, you can work for any employer. The difference with the H-1B is the H-1B is job specific, location specific, and employer specific. So if you go to work for ABC company and you've got an H-1B with that ABC company petition for you, and then you get a a better job offer with XYZ company, then XYZ company will have to file an H-1B petition for you because those are specific to the employer who files for them. If you're working for ABC and you start out in Mobile, Alabama, and then they decide, okay, we need to ship you out to Seattle, Washington, guess what? They're going to have to go in and amend their H-1B petition for you. Those are employer obligations, but still you need to understand the limitations of the H-1B. We talked about, if you're inside the United States, you graduate, you get your OPT, and then you file for a change of status to H-1B in the United States. Keep in mind, when you travel out of the United States, you will, of course, have to apply for a new H-1B visa. And so you have to factor that in. If you're going to be traveling, you have to factor that time in for the time that you may be out of the United States. With COVID, the delays in visa processing have been substantial and significant. And, hopefully that's going to get better, but you got to make sure that you're getting the information on how long it's going to take you to get that visa appointment or that visa interview appointment while you're out of the United States, so that you don't get stuck out for a much longer period of time than you would want. The other thing that I want to make sure that you understand about the H-1B, those have a finite life to them. In other words, the most amount of time that you can be in the United States in H-1B status is 6 years. And those are usually issued in 3-year increments. So when you change status to H-1B, you'll be approved for 3 years. And then you would have to file to extend that H-1B status for another 3 years. However, there is a huge exception to that 6-year rule. And if you have started your permanent residency processing, then you can, depending on where you are in that stage, you can renew that or extend that H-1B for either 1 or 3-year increments. So that is one of the things we're going to talk about today, as well as permanent residency, green card processing. But that's, you would want to have that conversation with your employer about permanent residency sponsorship as early as possible, of course. But if they're not willing to talk to you at the beginning of your employment, perhaps once you go in to renew that H-1B for that second 3-year period, that's really a good time to start looking at, okay, is this employer going to sponsor me for permanent residency? Because if they're going to do so, you're probably going to need to get that ball moving relatively soon to make sure that you don't run out of H-1B time. And the folks in the Career Services Office, of course, can help you and help guide you in having those conversations with potential employers, and having conversations maybe even once you get a job, to kind of give you some pointers on ways to broach those subjects with employers. But once you've proven your value to an employer, and if you're going to do that, surely you've done that after that first 3 years, then that may be the opportune time to have that discussion about permanent residency. Anything you guys want to add about that before we move on and talk about a few of these other categories? Or does anybody, you want to go over any questions, Charter?
We've had a number of questions, and I think some of them are going to kind of touch on these other categories that we get to a little bit later. Okay. I know we have a screen where we talk about the other visas that we haven't really discussed.
Yeah.
And we've got a few trade treaty types of questions that have come up.
Okay. All right, so let's move on to the next slide. Actually, go to the next one after that. Okay, so there are some other temporary options. Keep in mind, OPT, H-1B, those are all temporary options. And although H-1Bs may be valid, you may get 6 years out of that, or even more if you file for permanent residency. Those are not indefinite, and you can't count on just using a temporary category indefinitely. There are some categories that you tend to be able to renew over and over, and some that have a very finite period of time before you've got to have a permanent residency option. So I think I saw some questions maybe asking about Canadians. The TN is part of it's part of the NAFTA law, and I know there's another name for it now, but I can never remember it. So I'm just going to call
it. It's like YMCA, but US. USMCA.
Yeah, okay. Now, see, that will never go out of my head now. Thank you for that. Okay, so the TNs are, it's also going to be for professional positions, but it's only for folks who were born in Mexico or Canada, period. So that's one option that you may have. The TNs have some limitations, but if that is something that's available to you, you can bypass all this H-1B, cap lottery, and, you know, dancing the cap gap and all those different things that you need to do by applying for a TN. Those are typically applied for at the port of entry. So they're pretty, I don't want to say easy, but you're not going to be stuck in backlogs on visa interviews and that sort of time that you might face with other types of categories. And if you're seeing a trend here, all of these temporary categories are letters of the alphabet. So we call it an alphabet soup of immigration. O's, another category. You typically have to demonstrate exceptional ability in a particular area of expertise or skill. And for example, if just, let's say, for example, you've been working in a particular field, have demonstrated, gotten some major awards and that sort of thing, you may be able to demonstrate exceptional ability. But I will caution you that, you know, let's say you graduate in the top 20% of your class, that is not exceptional ability. Just academic accomplishments. You're going to have other types of accomplishment to qualify for the O, but it is something that, you know, some people are eligible to address. You said you had some questions about the treaty traders and treaty investors.
Yeah, so one specifically, the E3 from Australia,
Yeah.
you know,
Okay.
and whether or not, you know, is there even a path towards permanent residency? And I didn't know if E3 works like TNs do, where you can't be in a permanent or a tenure track position as a TN. You know, we have to use TNs for instructors and for researchers, but once they get in a tenure track, we have to use something else. So.
Yeah, the E3s are basically the Australian version of H-1B, and they're only available for Australian citizens. But I'm not sure about the position itself. I know that it has to be basically a position that is a specialty occupation. It very closely follows the H-1B as far as what's required. The main limitation is that it's only available for Australians. The other E's, the E1s and the E2s, those are restricted to companies who apply for those have to have, you know, substantial trade with the United States. They have to the companies have to be owned by the particular or by foreign national or from persons who are also citizens of the country that has that substantial trade. And then the beneficiary or the employee also has to have that same nationality. So those are limited. You know, E's are used by a lot of automobile companies. I see those automobile manufacturers rather that use those a lot in our region. Period. Treaty investors can be, I mean, it generally runs around the same, you know, it's got to be a company and the foreign national employee have to be, you know, have to be born in the country that has that substantial trade. And then the investors also have some additional money contributions that they have to make in connection with the trade. So those may not be something that you're looking at directly out of school, but it's a possibility. And if you go to work for one of those companies, it may be that they apply for those for you as well. Those are typically also consular processed. In other words, you know, in your home country, as opposed to a change of status in the United States. And there are reasons for that. Basically, you want the consular process because if it's quicker, and if USCIS, the Immigration Service here in the United States, approves the E, it doesn't necessarily mean that it would be approved once you left to go apply for a visa. So it's best to just consular process those at the outset. Period. There's lots of other categories and still more alphabet soup. If you want to hit that next page, Charter. The L's, these are intra-company transferees. So these are probably not going to be something that you're going to be looking at straight out of school, but it's something that may, you know, if you go to work for a company who has international operations and you're sent abroad to work, the L requires that a couple of different things. It requires that you have worked at least one of the last 3 years prior to applying in the foreign country at an affiliate or a related company of the U.S. company that wants to petition for you. And then you have to be in either an executive or managerial or specialized knowledge type of position. So those may not, you know, those may not be something that you're looking at right when you get out of school. Some others, you got your P's for athletes, either you're, you know, you're an athlete or you're not. And then your B's are for business or personal visitors, but now that doesn't come with any work authorization. Sometimes you may have to try to change your status to B to try to stay here until you can get the job that you need, but those are viewed pretty strictly. It sometimes can be hard to change status to a B just to wait around to try to find employment, because a B is not intended to be for employment purposes. One of the others, we have U's. The U visas are for victims of qualifying criminal activity. And these are going to be situations where someone has harmed you and you had to call police to help you. You reported the crime, you cooperated in the investigation and or prosecution and you know, either it's a qualifying criminal activity or it's not. The types of crimes that qualify are going to be your felony assaults, sexual assault, rape, domestic violence, and some other categories, including obstruction of justice and perjury and all sorts of criminal activity that can set you up for status, for the U status. The U does have a path to permanent residency, to a green card, but there is a pretty significant backlog in the filings for those. But if you are a victim of qualifying criminal activity, I would encourage you to, you know, to seek some immigration advice to see if that's something that may be an option for you. Okay. So we have any other questions about the temporary categories? Because I want to talk some today about, although you may not be looking at permanent residency as soon as you complete your program and your degree, but it's something you need to always be thinking about, because as we said, OPT is not going to last forever. H-1Bs and some of these other types of status are not going to last forever. So at some point you want to look at, what are the options for permanent residency? How do I obtain status to permanent status so I don't have to worry about this anymore and I can just, you know, be in the United States on a permanent basis? We got any questions on the temporary ones that we need to address, Charter?
Nothing so far. Some questions that came up about OPT, but I think it's all handled.
Okay. All right. So let's say you worked on your OPT for a while, and then this great employer said, hey, we're going to sponsor you for an H-1B. And now you've been working in that H-1B status for 3 years and you've just gotten it renewed, and your employer says, hey, I'm ready to sponsor you for permanent residency because I want you to be able to stay with this company for a long time. Usually the biggest question that I get, well, two biggest questions that I get with folks who are interested in companies who are interested in applying for permanent residency is, how much does it cost and how long does it take? In the how much does it cost? It really depends on which category you're applying in. And then is it a type of permanent status that the law requires the employer to pay for? That is going to kind of, determine exactly how much it costs to get through the permanent residency processing. As far as how long will it take? That's $1 million question. Again, that depends on a number of factors. One, it depends on the category. What type of permanent residency are you seeking? Also, your country of birth. If you're applying based on your employment, and you are from India or China, currently those country filings for applicants from those countries are backlogged, and some are facing several years, some are in the decades as far as how long it's going to take to complete the processing. So it's really important when you are thinking about and starting to work toward your permanent residency, you got to make sure you maintain that safety net. Make sure you are maintaining whatever that underlying status is, the H-1B, for example. You got to make sure that you're maintaining that, because if, let's say, for example, you're an H-1B, that H-1B is not impacted by your filing for permanent residency. You can continue to work and travel with your H-1B all the way up to the date that you get your green card. Now, some of these other types of status, that is not the case. H-1B has what is called dual intent. In other words, you can have your immigrant intent, which is that intent that you demonstrate when you file for permanent residency, but you can also still have the non-immigrant intent for the H-1B. That is not the case for some of these others that we talked about. We were talking about the O's and the TNs. Some of those, they do not have that dual intent. So what does that mean? That as soon as you start your process that you're going to lose that underlying status? No, that's not the case. You can get to certain stages in your permanent residency process. You can get through some of the first few filings that you have to do without it impacting your underlying status. But once you file that final step, which is called adjustment of status, you have clearly demonstrated immigrant intent, and you are not going to need to travel out of the United States until you get a temporary travel document that can also be applied for when you file your green card application. So again, maintaining your status and always, always, always making sure that international travel is something that is in your best interest to do. And that starts, while you're a student, and that's going to be all the way up to the point when you become a permanent resident, because, once you're stuck out, you're stuck out of the United States. You may, if you've got an employer who has sponsored you, that employer may not be willing to wait for you for, an indefinite amount of time. So that's something that you need to think about. All right, next slide. I want to kind of point out that there are really basically three paths to permanent residency, three major paths. One is based on employment, one is based on family relationships, and one is based on what I call protection categories. Protection categories are going to be like the folks who are filing for asylum, refugees, crime victims, human trafficking victims, and some of those types of categories. We're not going to really talk a whole lot about the protection categories. We're going to focus mostly on employment base. So we'll talk about some of these, and keep in mind that what we're talking about today are just various categories of employment-based green card processing. We're not going to get deep into the weeds just because we don't have enough time, but I want you to kind of understand some of the basics about employment-based sponsorship. Charter, next slide, please. So one of the types of processes that are available is called labor certification. Labor certification is basically a requirement of the U.S. Department of Labor. And what the U.S. Department of Labor policy says is before a foreign national can be offered a position for a green card slot, okay, permanent residency, that company has to make sure that there aren't qualified U.S. workers available to take that job. So the whole concept of labor certification is intended to protect U.S. jobs for U.S. workers. And there are various types of labor certification. One is going to require the employers to go out and place ads in the state employment office, the local newspaper, maybe some journals, other types of ads, employer website. And from that recruitment, determine whether or not there's a qualified U.S. worker. And if there is, guess what? You can't get the job certified by the U.S. Department of Labor for permanent residency processing. There is a special type of labor certification processing for teaching positions at a university. Keep in mind, though, if you do go into academia and you've got, let's say, an assistant professor or an instructor position, that special processing rule still requires a test of the U.S. labor market, but the rules are tailored a little more to universities in the way that they hire. So that's one option. If you go through the labor certification route, that start to finish, if you are not in a backlogged country category, that's India and China right now. That's subject to change, of course, but right now it's India and China, and traditionally has been. If you start your process using either one of those types of labor certification, I tell folks, at least 24 months, 18 to 24 months, start to finish, and it could be more. If you're in a backlog category, it could be years or even a decade or longer before you complete your processing. All right, next slide. There are also, for those of you who may be taking either in a postdoc position or maybe your next position is that of a postdoc, the national interest waiver category is one of those that a lot of times is about all you have available to you. With labor certification type categories, you've got to show a permanent position, and a permanent position a postdoc appointment is not a permanent position just by the nature of the appointment. So a lot of postdocs do file in this national interest waiver category. You've got to show that your work and what you're proposing in your work has both substantial merit and national importance. You've got to be well positioned to advance that proposed endeavor. And then on balance, you got to show that it would be beneficial to the U.S. to waive the requirement of a job offer and labor certification. Now, how do you meet all that? Excuse me. Depending on what your research work is, you can show that through receipt of grants, or other types of governmental support for your project. You're being well positioned. That's going to include things, what's your publication record? Do you have a job offer in the field? Are you, what are your contributions, and what have you done in connection with your proposed endeavor that makes you positioned to be able to continue working on that proposed endeavor? And then the beneficial to the U.S. to waive the requirement of a job offer, that can be demonstrated in a variety of ways. Again, we won't get into detail on all the different types of evidence that you have to show, but I did want to kind of touch on, look at, is a job offer impractical? What is is there an urgent national interest? Those are the keys that we need to be able to show with a national interest waiver petition. Keep in mind, labor certification, we talked about that. You've got to be sponsored by an employer for that. The great thing about the national interest waiver is you can self-petition. In other words, you do not need an employer to sponsor you for that. Next slide. The next slide just shows some of the types of documentation and evidence that you can include with your national interest waiver petition. And another thing that you're going to need are going to be letters from experts in the field that can speak to the national importance, the substantial merit, your position to continue to advance your project, and your leadership in the field. Anytime you can show that, in addition to your past accomplishments and plans for the future, all of that is important. We have any questions on national interest waiver?
We do. Sorry, I clicked me off of mute. One question came in about NIW. Can you apply during your PhD program?
It's not a bar to applying for it. It's whether or not you're going to be able to demonstrate well positioned to advance. Typically, if you don't have the degree, that's going to be very difficult to show, in my experience.
Now, we have had students who have applied, of course. I've seen a fair number of denials.
Yeah.
They put together a case that was then shut down. So there is risk in doing any type of case like this, any subjective type of case. But yes, it can be done. But make sure you check off the evidence, the list pretty well, and have a solid case before you devote a lot of your money and time towards it. That's what my recommendation would be.
And if you're working with an attorney on it, then the attorney should be able to evaluate, from reviewing your information, reviewing your CV, and talking with you to give you a general idea of the strength of your petition. Some folks are just ready to try and understand the risk that, hey, I'm going to submit this, and if it's denied, then it's okay. I'll try again in a few years when I've built my resume a little bit more. That's fine. If you are denied on your first filing, it doesn't impact or prevent you from being able to file again and try again, because obviously the decision on that first filing is based on, where you are, what your contributions are, and what the national importance is at that time. And if something changes, then by all means, you could certainly apply again. So that's a category that I think, like I say, if you don't have an employer who's willing to sponsor you, or if you just have a position that doesn't qualify for the labor certification based filings, then it may be something that you want to look at. I would encourage you to take the time and spend the money to sit down with an attorney who is experienced in these types of cases, who can, if nothing else, provide you with an assessment of it, do you have a 20% chance? Do you have a 50% chance? Some people are willing to gamble on 50-50. But if you've got a lawyer telling you, nah, you probably got a 20% shot at it, then that becomes a little different as far as your gamble, period. Right. Any other questions, Carter? I don't. Are you muted, Charter? Are you there?
I'm here.
Okay, good.
Can you hear me?
Any other questions?
Yeah. Can you hear me okay?
I can now.
Okay. Sorry. My computer's kind of starting to freeze up. I think I have too many things going on at the same time. The couple of questions that came up earlier were about non-F1. So we've been talking about the more typical F1 to OPT to H-1B path and then beyond. But we have one student who was asking about TPS, like what they can do to transition after TPS is over. Like, would it be possible for them to transition? And then similarly, a student who's on Daca protections, who has an EAD card based on Daca, what does their pathway look like if there's a possibility there?
Those are excellent questions. Let's start with TPS. TPS, of course, is temporary protected status, and it's opened up by the executive branch and can be extended by the executive branch, and a lot of those have been for several years. If you are in TPS, as long as you applied, immediately when it was available, then and you had some other type of status prior to that, then you'll probably be okay. If you have periods of unlawful presence, or if you had some sort of removal order before you were granted TPS, then you very well may not qualify to complete your processing in the United States, and you might be forced to apply in your home country. That's just something that you really would have to sit down with the lawyer and look at your history, because it is very history and case specific on, you know, which of the admissibility factors you may have violated during your time, you know, that you, before you actually obtain your TPS. Period. The Daca, as everybody know, and thing about TPS and Daca both, those are temporary programs. Okay. And the administration does have that, because those programs are not established by Congress. They're established under the executive branch of the government. Those can be taken away. And as we saw with the last administration, that was one of the things that they really tried to do, was to get rid of TPS and get rid of Daca and end those programs. Now, thankfully, they were not successful, but that, you know, was something that was on their chopping block. With Daca, you know, it is right now, it's that whole program is subject to litigation, and we don't know how long it will continue or if it will continue. The problem with Daca is you're granted deferred action, which is basically an agreement by the government not to deport you while you got that protection. You're not really in what's considered a lawful status. And with the employment-based processing, you have to show that you've maintained lawful status. So for some of those types of categories, you may be in a situation where you can't show that you've maintained status. So you might be forced to having to, you know, complete your processing outside the United States. So just that, again, that's something that you really just have to sit down with your lawyer and figure out, start it, you know, the first day you entered, and try to figure out what your status was during that time. Does that answer that question?
I think so.
Some of the other ones, did we get any questions about J's?
I had some questions earlier that I was answering. It was more about the J1 to transition to H1B. We didn't touch on the other implications of J1s, doing change of status or adjustment of status. Yeah, well, basically with the J's, if the biggest issue there is, are you subject to the 212E, which is a 2-year home residency requirement? Because if you are subject to that, you either have to obtain a waiver or you have to go back home to your home country for the 2-year period. Keep in mind that, you know, the 2 years is, you know, doesn't have to be, you know, where you're home, you go out for 2 years in a row. I mean, you can accumulate all the time that you spent at home to meet that 2-year requirement. But while you're in school, you may not have had enough time to satisfy that 2-year requirement. So you're either going to have to get a waiver or go spend some time abroad before you can either change to another type of status or apply for adjustment of status, which is part of the permanent residency process. So that's something that you need to be aware of. If you're subject to that 2-year rule, it's going to take you longer to get through your overall processing, even to change the status to H1B, depending on the category in which you're trying to apply for your waiver. You know, you may be looking at months or, you know, over a year just to get that waiver, and they're not guaranteed. I mean, those are, you know, those are highly subjective, different types, and every country is different on what they will agree to waive. And I don't think we have very many J's on this call. And it's, even if we do, not every J1 is subject to the 212E.
Okay.
If you happen to be on a J1 visa and you have any questions about the 212E or the 2-year home residency requirement that we're talking about, please feel free to reach out to me or Tron. Well, it is as clear as mud. It's a really difficult thing to understand. And it sounds a lot worse than it really is. There are ways to either apply for a waiver or to fulfill the requirement, and not everyone's subject to it. So that is something that comes up a lot, mainly with our postdocs. I'm expecting this question will be a bigger one for us tomorrow or Wednesday when we're meeting with the J1 researchers and H1B employees here at the university. So maybe not as much today.
Did we have any follow-up questions on the Daca? It seemed like I saw one or two come across.
I didn't see anything more, but at the same time, my chat is frozen. So
okay, all right. Well, that's fine. We can look at it at the end when we come in. I want to talk to you about one more employment-based category. On the next slide, if you go to work for a university, or if you go to work with certain types of research organizations, you can apply under this category that's called outstanding professor or researcher. Those do require that you have at least 3 years teaching or research experience, and that teaching and research experience typically is going to come after you've completed your PhD. And then you're going to have either a tenure track teaching position or a comparable research position. So it's going to have to be a research position. Postdoc won't qualify. It's going to have to be a research position that the intent is that job will continue. It's not just a short-term project that you're working on. Now, as the title of it indicates, are you able to advance the screen? No? Okay.
I can, yeah.
Okay. The outstanding professor or researcher category, that is not going to be available to everyone who is fresh out with their PhD. There are some criteria in addition to the 3 years of experience and the tenure track or comparable research position. You're going to have to demonstrate that you have been recognized internationally as outstanding in your academic field. And the types of evidence that show that would be major prizes and awards, including grants, membership in an association that requires outstanding membership to be included in that association, published material written by other people about your work, your own publication record, your participation as a judge of the work of other people. For example, doing reviewer activities for a journal, authorship, your own publication record, and then other evidence of original scientific research that can include conference presentations, patents, various other types of evidence. The one thing that I would note about the outstanding professor or researcher category, if you're looking at that, that particular category, you don't want to submit weak evidence. So if you don't quite meet those criteria, it's better to wait and file when you have more of the accomplishments. Because if you file with weak evidence, they'll use that against you. They won't simply just cast it aside. They're going to actually use it against you in the determination. And this is another one of those subjective review categories that if you apply, there's not just checking off the boxes. It's just making sure that you have met the standard for the outstanding professor or researcher. And like I say, it is a difficult category to meet, particularly early in your career. Now, again, these are going to be the types of employers that those would be available are going to be your universities and certain types of research organizations, which can include private companies if the research position we can demonstrate that it's substantially comparable to a tenure track teaching position. Period. We have any other questions about the employment base? I want to touch on a couple of things about family-based processing.
I've asked Trong to keep monitoring. My computer, I think, is overwhelmed by trying to record and do live transcript, and I've got 6 screens open at the same time. It may be time for an upgrade. Trong, do you have anything that you see in the chat that needed to be addressed before we move on? Okay, so I will follow up with her. Hold on. but I don't think at the moment. But let me work to chat with her on this. I'm using my phone to try to chat independently.
Okay. Well, let's talk a little bit about family relationships and how those factor into permanent residency. If you are married to a U.S. citizen, then you've got a track there that you can apply under in the family-based category, and you can be in and done from start to finish of your filing in 6 months or so. Those cases really do track very quickly and process very quickly. Of course, it has to be a bona fide marital relationship. You can't just get married just for immigration benefits only. That can get you thrown in prison. But as far as if you are married to a U.S. citizen, that is certainly a category that I would recommend someone just process based on that relationship rather than all these employment-based categories. If you have other family members who are U.S. citizens or permanent resident, the categories are limited. Not every family member is able to apply, but if you've got someone, if you have a parent or sibling or someone who maybe would be willing to apply for you, it really depends on the backlogs, on how quickly those can happen. But it's something to think about, at least if you are in that situation. If you're not, if you're already married to someone who is not a U.S. citizen, I don't recommend, trying to change that just for immigration purposes. Period. The one other thing that I would encourage you to make sure, we've talked about, don't wait too long, start planning early. We've talked about travel issues, making sure that you evaluate or discuss with your lawyer or international services office your travel plans, just so we can offer advice on whether or not you should do so, or at least tell you what the risks are if you do travel out of the United States. And then the other thing is waiting too long to plan for spouses. If you're married and your spouse is also in a temporary status and needs to apply with you, then you really need to look at that at the very beginning, because depending on what their status is, it may be that you're having to do things a little bit differently to protect their interests as well. And I've gone through the information I wanted to make sure that we address, but I am certainly happy to take questions for a few minutes, and let's see if we can make sure everybody's getting all the information out of this that they anticipated getting when they signed up.
Carol, is it okay to ask some questions?
Yeah, go right ahead, Tom.
Yeah. So I have a student ask, can I apply for the NIW during my PhD? I have completed my master's from UA and continuing towards my PhD.
Yeah, and I think that the issue with that is being able to demonstrate that they're sufficiently positioned to well positioned to advance their endeavor. That tends to be the problem, because most of your higher level research and impactful research and grant funded research and that sort of thing, publications, presentations, interest by governmental agencies, all of that tends to come with the PhD, at least during your PhD program. So that would be my concern if they were coming to me and asking me about applying.
Thank you. And I have a question from a Daca student, I guess. Because of Daca being a temporary agreement, would you suggest us as Daca students to try and look into applying for PR sooner rather than later?
Well, yeah, if you are eligible, if you have a sponsoring employer, or if you qualify in one of the other categories, it certainly is worth starting to work on it earlier rather than later. The hope has always been, from the time that the Daca program was first started, is that at some point Congress would make it permanent and make it a path to permanent residency for those folks who have obtained DACA. That has not happened yet. Obviously, we'd hope that with the new administration that the chances for that happening would increase. But again, there's difficulty in getting things done in Washington, D.C., and immigration does not seem to be their utmost priority at the moment. And so for us to say that, yeah, we're definitely going to get something done on DACA, I'm not comfortable saying that. But the biggest issue with DACA is whether or not you can establish that you maintain lawful status during for employment-based processing, and you just need to sit down with your immigration lawyer and look at that.
Thank you. Yeah, I think oh.
There's one person that asked if they can sponsor themselves. One person asked, can an international student, or an international student can't sponsor themselves, right? And for a teaching position, for a tenure track, can they sponsor themselves for an employment visa or for a green card?
The quick answer to that is, generally speaking, employment-based processing requires an employer to petition for you. And that's temporary, the temporary categories that we talked about, H-1B, et cetera. It also applies the same in the permanent residency, green card processing. There are a couple of exceptions to that rule. We talked about with the national interest waiver. You can self-petition. In other words, you sponsor yourself. You don't need an employer to agree to sponsor you if you're applying for the national interest waiver. There's one other category. It's called extraordinary ability. That's going to be your true cream of the crop, folks. That's going to be somebody who's in the very top percentage of his field. That is highly unlikely to be somebody who is just graduating.
Thank you. That helps a lot.
I have a question directly to me that you may probably can help answer, Carol. He asks, is there a minimum citation count that makes your case compelling for EB1 or EB1A or B?
The quick answer is no. The reason for that is because different fields publish at different rates. And Charter can jump in on this as well, because he and I have this conversation quite often. Some fields, if you might only publish, it might be normal to only publish 1 or 2 articles a year. And so your citation count is going to be less. Other fields may publish several times a year. So it really depends on, in looking at the number of publications that you have and the number of citations to your work, that is really we have to compare that against others in your field.
Yeah. And I'll say the same. It's not fair to compare someone in physics to someone in economics. In economics, it's getting 1 publication a year is pretty outstanding, actually. And then getting citations to your work, because the publication process is so slow, it might be several years before you have any citations to your work, because it just takes that long for people to publish. But in physics, it seems like they're churning out a publication every month. And so it's not an apples to apples comparison. And to Carol's point, what we usually try to do here is we do a good comparison within the department, and then across the field. We try to pull some data from reports that the University of Alabama's Office of Institutional Research subscribe to, so that we can get some good scholarly output comparisons. And that helps us to benchmark a little bit. So if we see the average for the field is 20 publications and 50 citations, and the person we're working with has 40 publications and 100 citations to their work, well, then we know that they're well above average and compared to others similarly situated in their field. So it's a very subjective area because it's a very subjective category of visa sponsorship.
And
So,
your EB1 categories and the EB2 national interest waiver, those are reviewed by an immigration officer, and they look at the case as a whole, if you will. I mean, there are certain criteria that you have to say, okay, I've met this criteria and I've met this criteria, et cetera. But overall, that officer is going to take your case and look at it and overall, have you demonstrated that international impact of your work for purposes of outstanding professor or researcher? For the extraordinary ability, I mean, that you have to show sustained international acclaim for your work, and that's a really high standard. And I know that there are folks who are able to obtain that. I've been fortunate enough to represent some of those, but I always tell folks that is the very cream of the crop. And you know, if you're fresh out with your PhD and you've got some good work under your belt, we can try it, but you got to understand that those are more often reserved for folks who have got some pretty substantial grants, awards, or they've been in the field for a while.
Yeah. One of the qualifiers for an EB1A is a Nobel Prize.
Well, yeah, if you have that, then yeah, you can get it.
It's like that's like you can have a Nobel Prize or the equivalent, or you can like have all these other qualifications that show that you're kind of on the way there. Not to say that you couldn't qualify, but I've worked in this field for 20 years, and honestly, I think Carol, yours and my case a few years ago was the first that I had ever been a part of for an EB1A case.
Yeah, and that was not a Nobel Prize winner, by the way.
No,
So,
but was he huge in the industry? Absolutely.
Oh yeah. Oh yeah. So that's what I'm saying. You're typically looking when it says sustained international acclaim. That's what it means. And you don't sustain the acclaim in a year or two. Are there some rock stars out there who could easily get an EB1A? Yeah, they were out there, but. And I've represented, folks in postdoc positions and or research type positions where they work for an employer that just wouldn't sponsor them for, an outstanding researcher. So they gambled and went on the EB1A, and we actually won it. But you have to go into those understanding. We all think we're great. We all think we're outstanding. And if you don't think that, you should think that about yourself. But it's not what we think or what our peers or colleagues may think about us. Obviously, that's important for your expert letters that support your case. But you got to, those immigration officers, they've got guidelines and they're used to seeing these cases. They're trained in handling these cases, so they know what they're looking for. And you've got to meet their definition of outstanding or extraordinary, as opposed to, what you or your colleagues may think. I always get this, and so I'm going to say this. I always get this. Well, I know someone who's in the exact same position as I am, and she got an EB1 approved. And the first thing that I say is, no, there's no way that y'all are exactly the same, number one. And number two, every case is different. And every case may get a different adjudicating officer. And you got some officers that are more likely to approve something that's borderline than you do others. So just be prepared that, in having someone evaluate your case, if you're looking at a national interest waiver or even outstanding professor researcher, if you go to work for a university or a research organization, you need to make sure that you have someone objective who looks at that and understands what those categories are comprised of, because, and it may be that you got somebody in your international services office, if you're working at a university, that can look at it for you. If not, you need to at least take the time and spend a little bit of money to get an attorney to look at it for you. Other questions?
So here's one, a question that came from one of our students. If I was to get an H-1B sponsorship at a CAP subject company, can I change my job to a CAP exempt institution during that H-1B? Like, how do I change employers? Or do I need to apply for another H-1B to make this change?
That is a good question. If you are subject to the CAP, in other words, if you are working for an employer who is subject to the CAP, once you have been counted in that CAP, you're good, at least for the 6 years or beyond the 6 year if you've got permanent residency started. But if you go to work for another employer, at that point, all the employers are CAP exempt because you've already been counted. So yes, you could, the second employer would just need to file an H-1B petition for you. Did I understand that question correctly?
I think so, yeah. And so, and just to reiterate, it's very easy. Once you've already been counted against the CAP, it's very easy to transfer or port your H-1B to any other employer, including CAP exempt employers like higher education. So that is definitely a possibility. We have a green card case, a question about the national interest waiver. Can an artist or an art curator contribute towards the national interest or contribution? Can they qualify under that NIW?
That's a really broad question because, again, with the national interest waivers, it's what is not only what the national interest is, but it's also what you have done in your, previously to show the substantial merit of your work. Thank you. And also what are you doing and what are your plans in the future in order to qualify for the national interest waiver. So it's not just a matter of looking at, oh, I'm going to be in this field, so will that one qualify? Because you've got to make the case on the national importance and whether or not, with substantial merit, if you've got government money that you've received for your, to fund your work or something like that, that's going to definitely point towards substantial merit. But again, it's a subjective category, and it's one that, you may have strengths in one area and weaknesses in others, but if you're, the strength of the, one of the factors may be enough to get your case approved. It's not something we can just check a box and say, yeah, that one will definitely work. That type of position will definitely work.
So taking a step back, there was a couple of other questions that came up earlier. One was a student had asked, when they were applying for a job, it said that the employer would only employ somebody who had lawful work authorization, what that meant exactly. A lot of employment applications have some interesting language that I've seen, and Joe, I think, addressed this more directly with the student, but I just wanted to kind of bring that back up. As you're on the job search, especially as you're trying to transition and maybe use your OPT, a lot of people are going to ask you if you will require visa sponsorship, and you might in the future. But remember, OPT is based on your status as an F1 student, so it's an independent employment authorization tied to you. So at least initially, you should be able to say, yes, I will have employment authorization before I start working, because obviously you'll have your OPT authorization. Now, the timing is something that can always be debated, but I don't want you to ever select no, that you won't have work authorization when actually you will. Now, you might eventually need that sponsorship. Would you say the same, Joe and Carol? Like, what would your thoughts be on a question like that in an employment application?
Well, in the research that I did for the student, I would, because I think the question was, would they still sponsor H-1B, right? And from reading the language that was on the U.S. Citizens and Immigration Services website, yes, they will still support H-1B. So I would go forth and still apply, even if they do inform you that they're only looking for U.S. citizens or I think what was it, lawfully? What was the correct terminology? I'm trying to find the question again.
Yeah, it's so far back, and of course I had to log into my phone to get access to chat again, and it doesn't show me anything before I logged in, so I've lost my that question.
I'll try to see if I can find it.
Then another question that came up too was somebody was asking about, can you only work for your employer that sponsored your H-1B? Yes, that's a pretty simple one. Most employment visas are employer specific and employment specific, meaning, and we were actually having this conversation earlier today, Trong and I, where we're talking about an H-1B renewal we are doing for a researcher here on campus who indicated that since we sponsored his H-1B is now also teaching classes. However, his H-1B sponsorship did not include teaching among the duties. And so that's something that we have to address in this H-1B as an amendment, basically, so that we include teaching as well as research, and that we address that properly, because your H-1B sponsorship is not a blanket work authorization. It is tied to the employer. It's tied to the dates that they sponsored. It's tied to the location where they sponsored you to be working. And it's also tied to the job duties that they sponsored you for. And if you change job duties, they have to file an amendment. If you change locations, they have to file an amendment. And if you change employers, the new employer has to file a sponsorship to have your H-1B moved over to them.
In Charter, if I can just repeat the question from the student, I just found it.
Oh yeah, great.
So Ms. Armstrong, they were wondering if an employer says that they employ only U.S. citizens and lawfully authorized non-U.S. citizens, does that mean they will not sponsor H-1B?
Probably.
Okay.
Because an employer can't say, hey, we'll only hire U.S. citizens, unless there is some sort of governmental clearance or something like that, their contract says you must be a U.S. citizen to come onto this governmental site. They can't just say, oh, they can't discriminate against foreign nationals as long as they have work authorization. However, they are not required by law to sponsor someone for either temporary or permanent residency. So the employer, if you walk in and say on your application, you have your OPT, they may ask you, do you have current work authorization? And your answer to that would be, yes, I do. But that does not mean that they will sponsor you beyond your OPT. And it may be that if you go into that job, you're not going to have, an opportunity for longer term employment. And I know that that's hard. I mean, Joe, your office, y'all probably deal with this a lot. You may not know that, definitely, but I'm sure your office is able to identify at least some employers who are, I'll say, immigration friendly. Because a lot of times employers really want a particular person, maybe that person is intern with them or something, and they really want to, to put them to work. But a lot of, particularly, I hate to say it, but smaller companies as well as larger companies that just don't have any experience dealing with immigration issues. So they get their first foreign national working for them. They don't have any idea what they need to do. Like I say, if they're going to work for Microsoft, you're good. But they're going to know what's going on in the immigration field. But a lot of other employers just don't know.
Absolutely. And just to chime in, we see the same thing. University of Alabama as a whole, yes, we know what to do. But then we have academic departments that have not hired an international staff or faculty member ever, and so they don't know what to do because internally they've not gone through that process. So we run through the same thing, and I see it too with small institutions. I know, Carol, you also serve other institutions, not just the UA system, and I can't imagine you probably have to deal with this a lot, kind of walking them through every step of the process, right?
Yeah. Oh, yeah. And you know, they're very often very surprised at what's involved and how much it costs, and why can't they just, why can't the person just go get another work permit? Why can't they just go apply? They've got this OPT card. Why can't they just go get another one or renew it or whatever? And I have to have that, have this, Immigration 101 workshop with them and explain that, hey, no, that's not the way this works. The OPT is limited in time. H-1B, they got to have another option to continue to work in the United States, period. It's not as easy as just filling out a form for a work document.
We had another question come in about the green card. So with permanent residency status, do you have equal chances for jobs as U.S. citizens in government labs and agencies?
I'm not sure I understand that question.
I think I do. So there might be, I know a lot of times for certain types of positions, and especially for grant applications,
Yeah.
you have to be at least a U.S. permanent resident or a U.S. citizen to be able to apply. It's not always the case, but generally speaking, U.S. permanent residents are almost always eligible to apply for anything that would be restricted to what would be considered a U.S. employee. But there might be some certain labs that still have very sensitive information where citizenship might be required. I would think that, some of your specialty government labs, that might be the case. Oh my gosh. So somebody else is asking about security clearances listed in job requirements. Are international students, can they qualify for getting security clearance? If so, how? It might be possible, but more than likely what they're talking about is security clearances that require U.S. citizenship or U.S. permanent residency.
Yeah.
And we see that a lot with some of the contract work that goes on. Now, that's not to say that somebody on an H-1B or J-1 or even OPT can't work on projects that are affiliated with that. But I think we would have to know more about it. And of course, that employer would know most of all. For instance, we just posted our job for our student advisor, and I've got one applicant that I'm pretty sure cannot qualify for the position because they don't hold U.S. citizenship or U.S. permanent residence, which is a requirement to be a DSO. Unless you have U.S. permanent residence or U.S. citizenship, you can't issue F1 I-20s or anything like that. So for us, we do put that as a requirement. You have to be a U.S. citizen or U.S. permanent resident to apply for the job. And I have somebody that I'm pretty sure does not hold that status apply. That question might have to come up again. So we got another question for H-1B visas where the employer has to prove that they could not find a qualified U.S. citizen in order to hire a non-U.S. citizen. Does that mean they will not hire you if a U.S. citizen also applied for the same position?
That's a good question. And when we were talking earlier, we were talking about labor certification. That is for permanent residency. That's for green card processing. It's not for H-1B processing. So the general rules with the H-1B is that, the employer has to, had some good faith recruitment and before, they start offering to foreign nationals, but it is not at the strict level of labor certification for the permanent residency. So if you're going to be applying for a permanent resident petition and you have to go through labor certification, the labor certification is a test of the labor market. And basically that employer that wants to sponsor you has to conduct certain recruitment steps to see if a qualified U.S. worker applies. If the qualified U.S. worker applies, does that mean that the employer has to terminate you? No. What it means is the test of the labor market failed, or at least for the basis of labor certification. And so the employer cannot use that recruitment to support labor certification. And sometimes they just have a cooling off period and try again. But it really depends on what the minimum requirements of the position are, and, you know, what the labor market is like, you know, for that type of job, as to whether or not you're going to have a qualified U.S. worker apply. So it's not so much the H-1B that has the issue with that. It's going to be your green card processing where that's going to be an issue with labor certification.
I think we're all caught up on questions. I hope we've touched on all of them. I know that there have been a lot, and Carol, you've gone through a lot of information, and we really do thank you for taking the time with us this afternoon. I will be, after we close this out, hopefully it saves properly to my hard drive and my computer doesn't completely crash. I laugh because I can absolutely see that happening, but I'm hoping to share this out with everyone. And that way you have a chance to go back and maybe listen into parts of it that maybe you missed or wanted some clarification on. But again, I want to thank everybody who joined us today, and I especially want to thank Carol for this wonderful presentation, and Joe for you and the Career Center for helping us put this on. We really, really appreciate you.
And thanks to you all as well for doing this. I think it's really helpful to give students this information and also help them start planning for the longer term. Like I say, that's the factor that is following us through the entire presentation with all of us is, you know, don't wait until the last minute. Start asking questions, start applying as early as possible, because otherwise the benefits may slip away from you. And once those timelines and deadlines are gone, they're usually gone.
All right. Well, with that, I am going to do my best to close it out. But thank you all for joining us today, and I hope you have a wonderful evening.
All right. Thanks so much.
Thank you.
Thank you.